Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Adib bin Muhammad Rahim. My metric number is 1201506 from TLC1. Book review. The title is Introduction and Effectiveness of Suluh in Sharia Court. So, in the chapter 1, the authors present to us about the history and the concept of suluh. So, basically, when there are the dispute, two options to overcome the conflict. The first one is resolution outside of court, considered as ADR, and the second one is litigation process. In this chapter also, the authors present to us about the history, the implementation of suluh before the revelation of Islam in Arab society. For example, one history that Rasulullah Nabi Muhammad SAW was elected as the third party to resolve the dispute among the leader of tribe in Makkah in matter of replacement of Hajarul Aswad after the big flood happened in Makkah. So basically the situation is before revelation of Islam and the election or the risalah of nubuwah Nabi Muhammad sallallahu alaihi wasallam. And after that, the authors also discuss in chapter 1 about definition of suluh. So basically the suluh is a result or decision that consent of resolution between the disputants. And after that, in this chapter also talk about provision of suluh from Quran and Hadith. So there is one verse from Surah An-Nisa, verse 128, and a hadith narrated by At-Tirmizi. The understanding of hadith is suluh is permissible as long as in line with Sharia compliant or there is no contradictory to the Sharia principle. So they also discuss about type of suluh. There is basically three of type of suluh. The first one is suluh by consent. It's considered as when the plaintiff agreed to do the replacement toward the right that has been disputed or the right of plaintiff claim. And the second one is suluh by denial. From the denial, any party tend to run suluh session. And the third type of suluh is when the accused keeps silent in any dispute or conflict. And also about pillars of suluh. The first one is offer and acceptance. The second one is the disputants of parties, and the third one is right of the dispute. This chapter is basic principle of suluh. So the basic principle of suluh is confidentiality, equality on speaking, floor and the duration, voluntarity in the making decision, flexible proceeding, the right discussed in accordance with Islam law, in accordance with Islamic law. The timetable of suluh session is marathon or periodically. Okay. Now we proceed to review on chapter 2. Basically, the authors present about suluh legislation in claims after divorce. So the provision related to suluh claims after divorce, among the related legislation is Sharia Court Civil Procedure, Federal Territory Act 1998, and Sharia Court Civil Procedure Suluh Federal Territories Rules 2004, and the other is Sharia Court Suluh Manual, and also the practice direction, and among the related rules is the number 1, state that there are stated 18 cases under the suluh. Next, the discussion on this book also about Sharia Court mediation in Singapore. But before the mediation session in Sharia Court of Singapore, there are one session called counseling session. Then proceed to mediation or proceed to hakam, then proceed to the litigation process. So now the discussion about suluh procedure in federal territories. So it started with the receiving the file of the information of cases. Then the registrar will set the date of suluh proceeding. After that, proceed to the session of suluh. So for instance, there are 4 levels in the suluh session. The first level is pra-negotiation, which is preparation and planning. The second level is negotiation 1, which is considered as persuading and proposing. Include also in this level is caucus session. The third level is negotiation 2, which is their process of bargaining and packaging the decision made by the party. And the last level is resolution, that is agreeing and closing. So after finish the soluh session, there are two considerations. If there are an agreement consent by the parties, then it is recorded as court judgment. Whether there are no agreement consent by the party, so it will proceed to the litigation process. The case will be brought before the court and the judgment by the court. Now, two terms or two status of cases we must know. The first one is successful. Whether the successful of cases based on consent from parties or the cancellation of claim, which is the plaintiff cancel the claim, and there is the second status of cases is unsuccessful. The first one is there is no consent on agreement, and it is also considered as not attend to the suluh session. So it also considered as unsuccessful. For this act, not attend to the suluh session can consider as contempt of court under Act 585, which is Syariah Court Civil Procedure Federal Territories Act 1998. There are no litigation, there are no legislation action for this article, for this Act Section 299. Because of what? Because of the basic principle of suluh itself, based on voluntary from the parties. So on chapter 3, they are discussed about the effectiveness of suluh in Syariah Court based on several items. So based on database Federal Territory Syariah Court 2014, then the case considered done with successful is 49%. The case done with unsuccessful considered as 23%, and they are not attend to the suluh session is 28%. The effectiveness measurement also based on the increasement of registered cases by the court registrar based on data 2010 and 2011 to 2014 in Federal Territory Syariah Court. Also consider suluh is effective based on the percentage of cases conducted by suluh. There is a positive number on the percentage of cases conducted by suluh. And the other view of effectiveness is based on percentage the effectiveness by the type of registered cases. So the most popular case registered under suluh institution is the first one, child custody. The second one, maintenance of child. The third is mut'ah. Fourth is matrimonial property. And the last is maintenance of iddah. So for instance, there is a percentage of cases conducted by suluh. So from this result of investigation by Federal Territory Syariah Court from 2011 to 2014, during the 4-year period, based on diagram above, the authors presented that 4,233 cases have been solved with successful through the suluh method, which is a high achievement of the suluh is 89.5% over the total of cases registered, and there is a moderate percentage of cases that successfully reach an agreement through suluh, which is 2,141 cases, or in the percentage is for 50.5% over the 4-year period. We can say that from suluh achievement, it's proven that suluh resolved with successful half of cases in court and reduce the burden of cases in court and avoid from litigation process. It is good initiative from JKSM. Authors present about improvement of suluh process. So several improvement suggestion from the authors is improvement of soft skill and knowledge among the suluh officer. The second one is enforcement of notice to attend suluh proceeding. The third one is spread the awareness, the advantages of suluh to the society. And my suggestion is it is good initiative if we can do the counseling process before proceed to suluh proceeding as implemented in Syariah Court of Singapore, so that the disputant can reduce the tempo of their emotion and can think rationally during the suluh session. And also in this session, the counselor can give any suggestion amicably to them during that session based on professional advice and consultation to make the disputant easier to achieve a consent on an agreement in suluh session. Because of what? Because of in suluh session, the mediator cannot give the suggestion directly to them. So in this counseling session, the counselor can take opportunity to give any suggestion that think reasonably. So that suggestion from my view. Thank you.